We are recording.
All right, thank you. Good afternoon. The appellate court is back in session. For the record, we are conducting this hearing via Teams and are live streaming this hearing on YouTube. Counsel advised that to the extent that there is statutorily protected parties or information here, that you take extra care not to reveal said information. I would ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, and finally counsel for the appellee. I am Judge Elgo.
Good afternoon, Judge Alexander.
Good afternoon, Judge DiPentima.
Good afternoon, Jesse Langer of Updike, Kelly and Spellacy on behalf of the appellant.
Good afternoon, Drew Graham from the Attorney General's office for the appellee, Commissioner of Motor Vehicles.
And good afternoon, James Healy from Cowdery and Murphy in Hartford on behalf of Appellee Insurance Association of Connecticut.
Now, for the record, I note that I can hear and see everyone, and please let us know in the course of your argument if you are experiencing any difficulties hearing or seeing the participants. If you should lose audio or video capability, please log out and retry the Teams link that you were set for this hearing, and we will take a pause in the proceedings. All participants must keep their video on and remain in view out of respect for the process and the participants. All participants are also asked to keep your microphones off and muted when you are not speaking. The judges will raise their hand if they have a question to avoid talking over whoever is speaking, but will interrupt if for some reason you do not see them. Please keep in mind that while this is a virtual hearing, all participants are expected to conduct themselves with the same formality and respect for the process as you would in our regular courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal and should advise me before you begin how much, if any, time is requested for rebuttal. Judge Alexander has kindly agreed to be our timekeeper and will be giving you a 2-minute warning and also an indication as to when your time is up. So this is the matter of towing and matter of towing and recovery versus Connecticut, docket number 43464, and we will now hear from the appellant.
Thank you, Your Honor. May it please the court, I'd like to reserve 5 minutes for rebuttal if I may. Thank you. The main issue presented by this appeal is whether an error of law concerning an agency's interpretation of a regulation is a reversible error when the factors in that regulation are permissive. I answer in the affirmative because an error of law should be corrected as it's for the courts and not for the agencies to expound and apply governing principles of law. The commissioner relies on the discretion afforded an agency as a general matter, but that discretion does not immunize that agency from an error of law. The regulation at issue, Section 14-63-36A, provides that the commissioner may consider operating costs of the towing and recovery industry in Connecticut. Operating costs play a primary role in determining the rates in a regulated industry. The commissioner cited to Connecticut Natural Gas Corp. Versus Public Utilities Control Authority. That's 183 Connecticut 128. In that case, the court discusses General Statute 16-19E, which governs the level and structure of rates for public service companies, which requires that rates be sufficient to cover the utilities' operating costs as well as maintain their financial integrity. That's at page 133. Another related statute also cited in that case, which is General Statute 16-22, uses terminology similar to the statute in this case, which is 14-66. That is, that the rates must be just and reasonable. Now, General Statute 16-19E, in the case of the utilities, does provide some guidance as to what constitutes an operating cost. Here, the regulation does not provide a definition of operating costs. In this case, however, we know that operating costs include insurance and real estate taxes because the commissioner considered them without a similar caveat made for record costs. The commissioner's decision also refers to general operating and administrative expenses as a factor in the base rate calculation when discussing real estate taxes, and that's at Appendix 8, paragraph 15. A wrecker, otherwise known as a tow truck, is an operating cost. It's a cost related to the operation of the business without which a licensed wrecker service could not exist, similar to paying the mortgage, payroll, or insurance. In fact, it's the most important operating cost of a towing operation. And I would refer the court respectfully to Appendix 191 and 221. In this case, most of the operating costs proffered by petitioner, specifically real estate taxes and insurance, increased at about the average of the consumer price index, which was 18.97%. The costs associated with the wrecker, however, increased multifold over the consumer price index. And that reference would be a, yes, Your Honor.
I guess what I find interesting is that you've framed your issues here as one of law. And then you've properly, I think, asserted that, that the law is determined by what is just and reasonable, and that you very clearly also articulated that the court may consider these various factors, which is what the court, in fact, did and certainly stated the legal standard correctly, correct?
Yeah, the agency did indicate that those factors may be considered. Yes, Your Honor.
Right, and the court, the findings certainly indicate that the commissioner also took into account record costs, correct?
That statement is in the decision. That's correct.
Okay, and so given that, and given that proper application of the law, the outcome not being satisfactory to your client, of course, but given that, how is that an issue of law?
It's an issue of, I'm sorry, Your Honor.
An error,
Yes.
An error of law.
Error of law. Yeah, it's an error of law because the paragraph discussing vehicle costs states explicitly that the statute does not list vehicle cost increase as a factor to be considered unless it's viewed as part of the consumer price index or as another factor that may be considered. And then the hearing officer and then also states that the statute must be given greater weight. So although an agency can consider factors and the weight of those factors, here what the commissioner did was, as a matter of law, isolate vehicle costs from the other operating costs. There was not a similar caveat with respect to insurance and real estate taxes as was made regarding vehicle costs. So it was isolated based on the interpretation by the hearing officer of the regulation and the statute.
Counsel,
Go ahead.
this is housekeeping. I'm having trouble finding what language specifically are you quoting from, please?
Yes, it is.
It's the commissioner, correct?
Correct. It was the hearing officer's decision, and it would be Appendix A7, paragraph 14.
Paragraph?
14.
Okay.
And the hearing officer says,
Yes, I see that.
yes.
Yeah. Okay, thank you.
That does not list vehicle cost increase specifically as a factor to be considered unless it's viewed as part of the CPI or as another factor which may be considered at the very bottom of the page.
Yep. So counsel, there's no citation to the regulation, correct?
Correct.
But it's your point, because you put it in your appendix, that regulation is 146336A that includes operating costs of the towing and recovery industry.
That is correct,
Am I
Your
following
Honor.
that correctly? Okay,
That is
thank
correct,
you.
Your Honor.
I apologize for interrupting your.
Oh, not at all, Your Honor. So we just discussed what the, at least what the petitioner considers to be the two legal errors that were made by the hearing officer and by extension the commissioner, which was again the fact that the vehicle costs are not expressly referenced in the statute, and then that the factors included in the statute must be given greater weight. And I would note for the court that the hearing officer reiterated this point during the remand proceedings when he stated, and this is on the record, would have to believe that the statute was first and would be given somewhat more weight. And that's at Appendix 430. So as to this first point, the commissioner's decision did not address the regulation at all, as Judge DiPantima mentioned. As a matter of statutory and regulatory interpretation, the commissioner differentiated between record costs and then the other operating costs proffered by the petitioner. If one were to apply the commissioner's interpretation, then insurance and real estate taxes would not be considered because they too are not expressly referenced in the statute. No operating costs are expressly referenced in the statute.
Well, sorry, Attorney Langer.
Yes, Your Honor.
The next page, it does say, or in A8, that the increases in vehicle cost is noted and consideration is given. So he's saying even though it's not mentioned in the statute, I'm looking at that and I'm considering that.
Yeah, yes. That is paying lip service to vehicle costs. And the reason that I say that is because when you read paragraph 14 in its totality, it's clear that the hearing officer is isolating vehicle costs from other operating costs. And in addition to that, the rate increase is just at the consumer price index. It's at essentially 19%. And so when you take that into account with the interpretation that's been set forth on paper as well as by the hearing officer during the remand proceedings, from petitioner's perspective, it's hard to separate the two.
Okay.
So the commissioner's position does not comport with the Administrative Procedure Act or the jurisprudence interpreting that act. It is well settled that an agency is afforded deference in its fact-finding and credibility determinations. But that deference is the deference to that agency's discretion is not unlimited. It must be employed with reason and in relation to the substantial evidence on the record. It must not be arbitrary. And important to the resolution of the issue here is the well-settled principle that an agency's discretion only extends to the interpretation of statutes and regulations if that interpretation is both time-tested and reasonable. An agency's interpretation, however, is not entitled to special deference if that interpretation has not been previously subject to judicial scrutiny. Again, it's for the courts and not the administrative agency to expound and apply governing principles of law. Although the Superior Court has considered two rate cases, the second being the present matter, the Superior Court has not construed the statute and the regulations specific to operating costs. To my knowledge, that issue has not been presented to the courts previously. If this court decides not that the agency's discretion overcomes a legal error, then an agency can interpret a particular regulatory factor effectively to write it out of the law because an agency has discretion in considering and weighing factors, which is what happened in this case. And I would also reference that in addition to the actual numbers with the consumer with the rate matching the consumer price index over the period of time in question, the commissioner admitted that fact in her answer at Appendix 41, paragraph 41. And so, as in response to the court's question, the language in the decision, along with the hearing officer's statement and the remand, really bear that out. In addition, to the improper interpretation of the statute and the regulation, the then commissioner acted unreasonably, arbitrarily, and in an abuse of his discretion. I spent a fair amount of my brief discussing past rate decisions. They reflect inconsistency, now magnified by the misinterpretation of the statute and the regulation. In 2006, the commissioner increased the towing rates based on documented cost increases. That's Appendix 183 and 84. 2 years later, in 2008, the commissioner denied many of the requests in a then pending petition, but did allow a temporary increase in the base rate on the cost of motor vehicle fuel. It's Appendix 360. Importantly, the then commissioner stated in that decision that the base rates are intended, thank you, to reflect and to cover all costs associated with non-consensual towing operations, including general, operating, and administrative expenses. That's A358. How can the base rates, particularly for light-duty tows, account for all general operating and administrative expenses when the commissioner disregards the most important operating costs, record costs, as a matter of law? And so the commissioner's effort to isolate vehicle costs under these circumstances, utilizing improper interpretation, amounts to an unreasonable and arbitrary decision. And I would note that the only CPA to testify classified record cost as an operating cost. The hearing officer not only disagreed with the petitioner's CPA, but affirmatively classified vehicle costs as something other than operating costs. Again, based on this interpretation of the statute and the regulation. So aside from that interpretation, there's no basis for why this classification was made, nor is there any evidence or other legal authority that's apparent, to, at least to me on the record, that the hearing officer was qualified to make that classification. And I would just add that because these are rate cases and not one-off matters regarding, say, license suspensions, there needs to be consistency in how the factors are interpreted and applied. This is separate, and I want to emphasize this is separate from the commissioner's discretion to weigh the evidence and determine credibility. And so I would just mention, as I know my time's coming to an end, layered into that abuse of discretion is the unreasonable analysis of the other operating costs, which is discussed in detail in my briefs. And so, thank you.
Thank you very much, Attorney Lang.
Thank you.
Attorney Graham, and if just everyone would mute, thank you. Not you. Thank you very much.
Thank you, Your Honor. I'm obviously happy to answer any questions as a follow-up to your direct questions to counsel. In the meantime, let me list for you the several reasons, the broad several reasons why this trial court's decision should be upheld on appeal. First of all, the hearing officer had broad discretion to weigh the factors listed in the statute and regulation to reach his rate increase decision. Secondly, there is substantial evidence showing that the hearing officer considered all factors raised by the plaintiff at the hearing. Third, the hearing officer did not rely on any specialized knowledge in rejecting the plaintiff's expert witness testimony on record operating costs. And lastly, the hearing officer's rate increase of 20%, after all, this is a rate increase of 20%, was just and reasonable for both the plaintiff and state consumers. Regarding the first issue, Your Honors, the language in the statute and regulations shows that the hearing officer has broad discretion to weigh the listed factors because it has that language of may consider, which the appellate courts have construed as very broad. May is broad discretion, according to the appellate courts. The trial court agreed with that, relying on a Supreme Court case, the Weens case, to conclude that may indicates discretion is authorized concerning the listed factors. Consider, according to the dictionary, means to take into account, which is another way of saying weigh, and the trial court recognized that as well, stating that the hearing officer has discretion in determining the weight, if any, to give to any particular factor in light of the evidence presented. Along these lines, the trial court rejected, for these reasons, the trial court rejected the plaintiff's argument that the hearing officer improperly relied on the statutory factors more than other factors, stating that challenged the hearing officer's authority to weigh and use his discretion, both of which are squarely vested in the commissioner. And that is supported by the may consider language. The broad may consider language supports the trial court's reading of the statute, that the hearing officer has the discretion to weigh any one factor more than another. And according to the Murphy case, the standard Murphy case, which applies to all administrative proceedings, courts cannot substitute their judgment for the hearing officer on the weight of the evidence. And for these reasons, the hearing officer had the authority to weigh, for example, CPI more than record operating costs that are listed in the regulation. In fact, he was not required to consider any other factor in the statute or regulation. But even though he wasn't required to consider motor vehicle operating costs, he did so, as Your Honor, Judge DiFatima pointed out on page PA8. He said specifically, after addressing the issue, nonetheless, the increase in vehicle cost is noted and consideration is given to it here as a factor in the base rate adjustment. So after all that was said by counsel, the fact of the matter remains is the hearing officer considered operating costs in his decision. And although the hearing officer stated that he placed more weight on the statutory factors, he did not say that the regulation was invalid. And our position is the regulation is not identical, but it is consistent with the regulation. So the trial court's conclusion that the hearing officer had broad authority to weigh the evidence as he saw fit was legally and logically correct, Your Honors. It was not clearly erroneous. Regarding the second issue, Your Honor, the record shows that the hearing officer considered all the factors raised by the plaintiff. The CPI, the plaintiff brought forth evidence on CPI, real estate taxes, workers' compensation, and motor vehicle operating costs. The hearing officer had full discretion to weigh the evidence on all these factors in reaching his rate increase decision. CPI happened to be undisputed. That's a 18.97% raise that all parties agreed to. Real estate taxes, not one of the factors listed in the statute, but the hearing officer considered evidence anyway, concluded it was part of general operating and administrative costs, and that conclusion is supported by evidence presented by Connecticut Legal Services, which stated as much in one of its submissions to the hearing officer. Workers' compensation, also not a factor included in the statute or regulation. The hearing officer, again, listened to the evidence provided by the plaintiff, who claimed that the premiums went up. IAC, represented by Attorney Healy, Insurance Association of Connecticut, provided evidence that the rates went down. The hearing officer did not incorporate them into his rate increase decision, as was his authority to do so according to his broad discretion. Regarding motor vehicle operating costs, the hearing officer considered those costs as we see in the first decision on page PA8. But in addition, the hearing officer heard a substantial amount of evidence on it from the plaintiff at both hearings. At the first hearing, the plaintiff presented a plaintiff expert witness who claimed that the average lifespan of a wrecker was 5 years. And in that evidence or assertion was rebutted by evidence submitted by Connecticut Legal Services, who provided information from a towing operator pointing out that, hey, this towing operation, at least this one, has records that are 10 years old at least. And the hearing officer looked at that and said, you know, that's just a small sample size, right? That's just one example. That's not enough. This is in paragraph 14 on page PA7, same paragraph that we've been looking at. So that's not enough to overcome this expert. But you know what? I still don't have enough evidence to show me that the plaintiff's claimed lifespan, that the claimed average lifespan of these records equates to years in service. And if you look further in that paragraph, you'll see that the hearing officer told the plaintiff what he needed. He said, I need production of documentation on vehicle replacement history of your members, of the TRPC members, to assist me. He's asking for his help. Show me this evidence so I can consider it. Well, as it turns out, the plaintiff got a second bite at the apple at the remand hearing and showed up with the same expert and said, here's the evidence. We've got all these records from 2014 that are new. That should resolve it. And IAC rebutted that evidence and pointed out to the hearing officer that no, that is the plaintiff. The plaintiff is wrongly assuming that these newly acquired records are replacing old records, are replacing the ones taken out of service. But it doesn't. It doesn't tell us anything, as IAC said. That tells us nothing about how many old records are coming off the road. So the hearing officer had the discretion to weigh that evidence and conclude that plaintiff still had not equated average lifespan of records 2 years in service. Nonetheless, again, despite all of this evidence, all this consideration, the hearing officer still put in his decision. I consider it as a part of as a factor in the base rate adjustment. I want to briefly address the prior decisions raised by the plaintiff's attorney, counsel, your honors. There was a case in 2006. I don't know that it's really relevant to this case. There was a heavy duty fee increase granted by the commissioner. There was a light duty fee denied by the commissioner. The heavy duty fee hadn't been raised in 9 years. The light duty fee hadn't been raised in 3 years. It seems like the lesson drawn from that is the more time between raises, the more likely commissioners are likely to allow your rate increase.